Well, this is a case that was instituted about the start of the life of the 10th Assembly in August 2023 by the Socio-Economic Rights and Accountability Project, SERAP. And well, we have now gotten a judgment. Well, the judgment was given in May, but the certified true copy was cited just over the weekend. And the Federal High Court sitting in Lagos has now declared unlawful the National Assembly's controversial 110 billion naira vehicle and allowance schemes, ruling that the spending of 40 billion naira on 465 vehicles for lawmakers and 70 billion naira in support allowances for the newly elected members at that time breached procurement laws, constitutional obligations, and the public trust. It's a very, very interesting case, and we have joining us on the program to walk us through this, the implication, whether it can be, retrospective in that sense, is legal practitioner Mr. Malaki Ogumaju. Good morning, sir. Welcome to the program. I'm delighted to be here again. Good morning. Well, the court has made a pronouncement, but this is 2026. It was instituted 2023. And how do you say that water may have passed under the bridge? So how does this work, first of all? Let's see how to operationalize this judgment. And is it law now, or is maybe a step forward in the right direction?
Good question. I'd like to start by commending those who found it worthy to go to court, in particular the SERAP and the judge, the Federal High Court, so to speak. On the part of SERAP, you could see the creativity, the legal fireworks that culminated in that conviction that we could tweak the law by instituting this kind of matter. Because generally, what used to be is, oh, no, you can't do anything. An arm of government cannot dictate to the other how to operate. In other words, the judiciary cannot adjudicate with respect to legislative activities. But this judgment has creatively found a way to situate the law within the context of the bigger, larger polity of Nigeria. And what it has done is to say, you can't use that as a shield where there are issues of illegality. In other words, even if the National Assembly has its autonomy, so to speak, you cannot be operating arbitrarily and then expect that anyone who resists that. In fact, and I'm putting out that as the defendant brought that up by way of preliminary objection, and it was overruled. So I seriously commend SERAP. I commend the judiciary, the Federal High Court. It will be interesting to see what happens next, if there's an appeal, but one would advise that there should not be an appeal, because we're all in this country together. Now, coming to your question, you could see that this is a novelty, and it's in progress in terms of what happens next. I think that the civil society groups, advocacy bodies, should take it up from here and make a serious case out of this judgment, because I know, and I have appeared repeatedly before Justice Bogoro, my Lord Justice
Bogoro.
Like I told one of our senior professional colleagues this morning while coming here, I am so fascinated by that. I didn't see that much fire in her. It takes so long to come this hard and clear against institutions of government. But I'm sure he didn't do it sentimentally. He did it according to the law, because she was certain. Sorry, my Lord Justice Bogoro was certain regarding the constitutional implications of what they did. She touched on the Public Procurement Act. She touched on the Code of Conduct for Public Officers, and so on and so forth, and wondered why such an arbitrary behavior could be envisaged, let alone accommodated within the present economic realities of the country. I think that the bigger point my Lord made is that except until you comply strictly with the law, such an arbitrary behavior can no longer be accepted. And that's where we are now.
And as Kade said earlier that, this is coming well over 3 years after the judgment was, nearly 3 years, judgment was instituted. So is it coming after the fact? And in terms of implementation, where do we go from here? After the fact being that those purchases have already been made in the life of this 10th Assembly. So how will implementation be executed? So
you find that in part of the judgment itself. I haven't read the certified true copy, meaning that, like you said in your intro, it was cited yesterday, just as persons with deep interest, you try to get as much as you can from what is in the public. But the judgment talks about a direct admonition on both Akpabio as the Senate President and his counterpart, Dr. Tajuddin
Abbas,
to ensure, moving forward, strict compliance with these extant statutory provisions I have mentioned, i.e. the Public Procurement Act, in fact, Section 54, Subsection 4, the Constitution itself that speaks about the separation of powers, and then even the Code of Conduct for public officers. But I'm saying, if you talk about the 3 years timeline, well, for an action that is most likely instituted through originating summons, that's what we call it, just for the declaration and interpretation of, you could say 3 years, but it's within time. It's within time. The big news is that we now have this. This is what we call case law. In fact, Nigerians should be reminded that there was a similar case less than 3 years ago. The judgment was less than 3 years ago. The one instituted by our friend Monday Obani. In short, it was Femi Falana who argued that case. Similar case on the same point. So where we are now is that within the context of law, this matter has been situated and largely settled. Namely, that you cannot use legislative autonomy as a shield. It does not operate as a shield against arbitrariness. In other words, you cannot, on the basis of the fact that you are legislating for the country, begin to act arbitrarily in a way that undermines the laws you passed yourself. And here is the bigger point, as one who is trying to analyze this situation. Even the business of budgeting needs to be interrogated somewhat in a way to emphasize the beauty or the essence of this judgment. The Constitution talks about the executive laying the budget. What it means is that they prepare it, they bring it before the National Assembly. The National Assembly vets it through their legislative powers to confirm whether, for instance, they say this building will cost 2 billion naira. And the legislature says that even in Ghana, similar building is less than that. So you, the legislature, cannot, like we see these days, hype that price, cannot increase that. You cannot do that yourself in terms of the appropriation. But what we see these days is that it is the National Assembly, besides the laying, it is the National Assembly that determines what they collect in terms of these allowances. It is the National Assembly that sees what the executive brings. Instead of 5 billion, they take it to 10 billion. So you are practically usurping the powers of the executive by determining, and what is more, Section 70 of the Constitution of the Federal Republic of Nigeria is very short sentence there. It says that the fixing the salaries of the members of the Senate and House of Representatives shall be determined by the Fiscal Mobilization Allocation Commission. In other words, it does not lie in the mouth of members of the National Assembly to fix their own salaries, their own allowances. But that is what we have had.
So is it not going to touch on the powers of appropriation of the National Assembly?
Just say that again.
This judgment, isn't it touching on the powers of appropriation of the National Assembly?
No,
and won't they find it as grounds of appeal?
No, well, grounds of appeal is always there to be explored, but the law remains the law.
So let's how did we get here? Mm-hmm. We got here because vehicles were, so I want to know what I haven't seen the CDC, so I'm reserving my comment. What is the law, the judgment trying to address in specific? Because what got here was the fact that vehicles were to be bought for the senators and to the members of the assembly. Mm-hmm. In fact, I think it was the spokesperson of the assembly that said that they are operational and official vehicles, not personal gifts, and remain the property of the National Assembly during their members' tenure. So is this judgment frowning at members of the National Assembly getting operational vehicle, one, or is it frowning at the amount used to buy these vehicles, or there was challenge with the procurement process itself?
Correct. So let me take it from your preliminary question. How did we get here? This amount, this figure, cumulatively 110 billion, was found or was appropriated in the supplementary budget of 2022. Supplementary, after the main one. And for them, it was to be for the procurement of the vehicles and what they call support allowances. So I've quoted the law now to say the salaries and allowances of members of the Senate and House of Representatives, the word is shall. That word in law is peremptory, it's mandatory. You don't have room to maneuver. Shall be fixed by the Revenue Mobilization Allocation and Fiscal Commission. Once that is certain, the question would be, was this appropriation by the National Assembly, i.e. Senate and House of Rep, was it appropriate in the eye of the law? This time around, it's not just the law, statutory provisions or we're talking about the ground of the Constitution. So what the court has done, because that now goes to your question, is to say that you cannot rely on your legislative autonomy and ride roughshod on the Public Procurement Act, which is the law we have today to deal with issues of accountability, transparency, and due process. Section 54, subsection 4 of the Public Procurement Act, 2007. It also frowns at your own oath of office. My Lord Justice Bogoro was also wondering about the fate of budgeting itself. To what extent will it be the responsibility of the National Assembly to do the work of the executive and that of the legislature all together?
So I was saying in essence, for instance, just picking back from what you said, from this judgment, if the National Assembly sees the reason to increase the budget as presented to them by the executive, the right thing to do is to revert.
That's correct.
Rather than increase on their own.
The National Assembly cannot do the work of the executive. That is preparing. It is the executive that lays it before the National Assembly. The National Assembly, as a watchdog, is essentially to moderate the possible excesses of the executive. So you cannot sit in the chambers and increase the figures proposed. That's a proposal. You cannot.
I know.
You can do well if you say it should be reduced, but you cannot and pass it. Then you are becoming a judge in your own case.
Mr. Gumada, it's a very interesting conversation.
I find it
very
interesting.
This judgment is quite telling because the judge, Justice Bokoro, said, I have taken judicial notice of the economic realities in Nigeria and the widespread financial hardship affecting Nigerian citizens. In this context, the allocation of 110 billion naira for the benefit of lawmakers demonstrates a failure to prioritize national interests. And it goes on. But we have just less than a minute to wind up, Mr. Okumado. There's always been that call for some sort of autonomy when it comes to finances. For even the judiciary, right? You should not have a case where the executive is one building houses for judges, procuring cars for them. They say that it messes up that whole sense of independence. And the National Assembly could well say, well, we need to have some power of the purse too, so we don't have to rely on an executive arm to get us the money that we need. Now, your time is 30 seconds. Does this align?
Two things. If they wish to achieve that, they should pass a proposal for the amendment of the Constitution. As the law stands today, they cannot. And we have read out the sections of the Constitution.
And the judiciary too does not have that autonomy of the purse.
And the judiciary has not been found wanted, at least on this score. Yeah. We have identified the legislature, Senate, and House of Representatives running foul of this constitutional arrangement and the statutory provisions that regulate what they ought to have done. So if they wish to achieve that, they should be thinking about the amendment. And the amendment should not be carried. It should not be approved because there is the need to have serious safeguards on all of these aspects of our national lives. Otherwise, we won't be practicing democracy. People will perfunctorily abuse their powers.
We hope this will be a landmark case that will then guide their actions moving forward. Mr. Malaki Gumadu, always a pleasure having you. We hope that this does better for our democracy and spending.
Very healthy. Thank you very much.
Thank you.